And welcome, Employment Hour in 30. If it's your first time, welcome to the show. We talk about employment law, workplace rights, and that's what we do here. 1-855-821-5900. Hey, I got the phone number right anyway. We got a busy show today. We have your partner, Lior Sivan Tumarkin, coming on, talking about disability law. Has his own show, of course, In Your Corner, if you've ever caught that. Good show as well. We'll be hosting that in a little while. But first, lots to get through. We're going to talk about the severance pay calculator. A lot of emails, phone calls to get through from our radio show. EmploymentHourTV.ca, by the way, if anytime you want to go to that website, find where you can catch our radio show, which we've been doing over 7 years now. So a lot of success there. We'll get to some phone calls from that show. First week that was, what have you got going on, pal?
Yeah, and a lot of employment law issues come up all the time. We're going to have Sivan over in a few little minutes here to talk about the interaction between employment law and disability. What happens if you're on a disability leave, if your insurance company won't pay you, if they cut you off. And I'll talk about what happens if your employer gives you a hard time. But on this show, we tackle employment law, workplace rights. We talk about all the issues that you need to know if you're working, have a job, had a job, maybe you lost it, you want to know what your rights are. Well, no need to wonder anymore. On this show, we'll talk about that and many other topics as well. And don't be bashful. If you ever want to know more about your specific situation, call me at the office, email me. We'll give you that contact information throughout the show. No bad questions. I'm always happy to talk. It's what I do most of my time, John. I answer questions, so there's no bad question whatsoever. But on this show, we always like to start off with a segment called The Week That Was. I talk about a situation that came across my desk just over the past couple of days. So this situation involved a gentleman who has been on a medical leave for 6 months. While on medical leave, he did the right thing. He was in touch with his employer. He told his employer he's seeking his treatment. He's working on getting better. He told his employer he's going to get reassessed. Well, when he was ready to finally come back to work, his employer tells him, well, no, we have a policy. You can only be off for 2 months. After 2 months, we have a right to find a replacement. It's automatic. We don't have to consider you, and we consider you to have resigned. And this was absurd. It's a ridiculous thing to do. And this person, rightfully, because he watches this show, he called me and he said, Lior, I have a hunch that this is illegal.
Yeah, a little bit.
Can you confirm that? Well, yes. Of course, it's illegal. You can be off as long as you need to, whether it's 2 months, 6 months, 12 months, or anything else to get better, okay? And as long as your doctor backs you up, as long as you have a valid medical reason to be off, you can be off. Now, that is not a resignation. It doesn't matter what policy your employer has. It doesn't matter what their expectations are in terms of you coming back. If you can't work, that's it. You remain an employee. You continue to accrue seniority. When you're ready to come back to work, your employer has to make all efforts to take you back. The same job, same compensation. It's only if your employer tried to find a job for you, but they couldn't. There's no job legitimately. There's nothing that they can do that they're allowed to terminate you with your full severance. But there's no such thing as saying you've been gone for too long. There's no such thing as saying you've resigned. Nonsense. If you're sick, be off work, get a doctor's note. That's all you need. If your employer won't let you come back to work, call me. I'll help you.
1-855-821-5900, by the way, is that number. Is it not also true and illegal for your employer to not be able to admit these simple words? What's wrong with you?
Yeah,
you can't do it.
It can't do it. You would think it would, and I've seen literally every week I probably see employers asking those questions. Tell me what your condition is. Tell me what medication you're taking. What kind of treatment are you getting? Nonsense. No, an employer cannot ask that. We call this the difference between prognosis and diagnosis. You've heard me say this before. Prognosis means how long are you going to be off work? What kind of accommodation may you need when you come back? Those are legitimate questions. Your employer can ask that. Your employer cannot ask, what kind of condition do you have? Do you have insomnia? Do you have a bad back? Did you break your arm? None of that matters. Your employer cannot ask that. What medication you're taking, what specialists you're seeing. Those are all private, personal pieces of information. Your employer cannot ask that. You don't have to provide your employer that information. As long as you're providing a simple note saying, I cannot work, frankly, that's all the employer is entitled to know.
EmploymentHourTV.ca is the place to go. You'll want to catch the radio show. There's a way for you to find which one you can catch it on. From the show every week, we take a ton of phone calls on the air, and we cherry-pick the good ones. Well, they're all good, but we cherry-pick some of them. We play them back here, and we talk about them. So first phone call's coming up.
I've been employed with a company for close to 20 years, 47 years old, in sales. They're closing down a few of their stores. They're sort of cutting back, and I was told that they won't be needing me anymore. So I'm thinking this 6 months notice that they're giving me, is that pretty well the thing that they just have to do?
Well,
Yeah, no.
Yeah, no. I think that's going to be the theme with a lot of the questions.
Yeah, no.
No. So that's not the case at all. So this person got 6 months advance notice of the termination of his employment. That's perfectly fine.
Yep.
An employer can, and in some cases often do, give advance notice. And that notice does count towards your severance. So if you're owed 15 months severance and you get 6 months notice, that 6 months counts towards the 15 months.
Right.
But you still have to get the balance as payment, as severance. So this person, after 20 years of employment, got 6 months notice. Is that enough? Well, rather than me tell you, by the way, it's not enough, but rather than me
Shocking.
tell you the specific amount, let's actually plug that into severancepaycalculator.com so that everyone at home can see exactly what this person is owed. So severancepaycalculator.com, we have some fields to fill in. He's in sales. He's been there for 20 years, 47 years old, and was given 6 months notice. Well, Severance Calculator correctly assesses him as being owed 16 to 20 months of severance. 16 to 20 months. Now, he got 6 months already. So he's owed 10 to 14 months, the difference in payment. So it's not enough, and he was owed much more compensation. And remember, if you get working notice, but you leave before that notice ends, you may be considered to have resigned, and then you don't get any more compensation. But just because you got notice doesn't mean you're not owed severance on the back end. In most cases, you are. Go to severancepaycalculator.com to find out how much you're owed, whether you've been just walked out of the office right now or got advance notice of the termination. You may have significant entitlements.
You know, it's funny, we can't stress enough how often or how regular people should be when they go and check out severancepaycalculator.com. And I think we talked about this before. We had a phone call a few weeks ago where a gentleman was, I don't know what, late 60s, early 70s. He got about $20,000, and he was owed $160,000.
Yeah.
And it was too late.
We were talking with him on air on our radio show.
Brutal.
And live there, and the math was such that he was owed $140,000, $150,000, and I had to tell him, unfortunately, I can't do anything. You've walked away from those entitlements, $150,000. Now, you may not be owed an extra $150,000. It may be $20,000 or $50,000, but it could still be, and often is, a significant amount. So don't let that happen to you. If you lost your job, you cannot sign off on that severance offer. I've said it before, but I'm going to say it every show because it's that important. Call me, call another employment lawyer if you don't really like me for whatever reason. Go to severancepaycalculator.com. Do the smart thing. Don't walk away from money that you're legally owed.
You can call or email Lior anytime, member of his team, or you can go to terminationquestions.com. That's a great resource to ask your questions and get them answered rather quickly. I'm going to read one from it and get you to answer this one, Lior. John writes in, says, I was terminated without severance after receiving one written performance warning. The company policy says that if we don't meet a performance requirement, we will be given a written warning and provided with additional training, which didn't happen. Was I wrongfully dismissed?
So let's start with the idea that the company is allowed to let him go, even though he didn't do anything wrong, really, or even though they didn't follow their policies. They're allowed to let him go as long as they pay him proper severance and his full severance. And for that, he can go to severancepaycalculator.com. But I think the real question, what he's asking is, can they let me go for cause? Mm-hmm. Can they let me go without any compensation, without any severance? Well, the reason is no, absolutely not. Now, to let someone go for performance reasons for cause without severance is almost impossible. You'd really have to show that the employee went out of his or her way to do a bad job. That's very difficult to do. So, no, it's difficult. Now, in this case, it's even more difficult because the company has a process in place saying, hey, if you're not going to do a good job, we're going to follow these steps to try to improve performance.
Right.
So if the company skips the steps and tries to terminate for cause, that's going to make it that much more difficult. A company is expected to follow its own policies when it comes to disciplining in terms of improving performance, and if they don't, it's going to be that much more difficult for them to try to terminate for cause. But if you're watching us right now, anytime your employer lets you go for cause, even if you feel you did something wrong, you may still have significant entitlements. So for that reason, you need to reach out to me if you lose your job. For cause, without cause, the same thing.
1-855-821-5900, by the way, is a number. employmenthourtv.ca. As I mentioned earlier, that is the place to go to find a radio show and a station where you can catch the show. Call number 2 for the day is coming up right now.
About 15 of us were let go today, all together in a group. My question for the group is, what kind of severance we could expect. We were all on contract, the majority of us. I also wanted to mention there's a couple of employees who were let go were actually pregnant.
Wow, it's a lot to unpack here. Pregnancy all in one shot, it's a lot, right?
On contract.
Contract.
Well, let's start with this idea of being on contract. Probably that's a silly concept, I would think, in a situation like this. If you have a job, you are an employee. You can't call yourself something else. You can't have the company call you something else. You're not really on contract if you have a regular job. It's as simple as that. You're owed severance if you lose that job. Now, she's calling on behalf of some 15 employees. The reality is they all have their own individual entitlements. So some person may be owed 24 months severance, some person may be owed 6 months, again, because it's based on your age, your position, and the length of your employment. So different people have different entitlements. What I can almost guarantee you that they're going to be owed a heck of a lot more than what they've been offered. Most people are. Now, she mentioned someone getting fired while they were pregnant. If you're fired because you're pregnant, even if it's part of the reason, that's illegal. That's a violation of the Human Rights Code. It's a violation of the Employment Standards Act. It's wrong, it's illegal, it shouldn't happen, and you can have significant entitlements. Now, if you were let go as part of a big group, nothing to do with your pregnancy leave, then it may only be a severance issue.
Right.
So you're right, there's a lot to unpack here. And what I say in these situations, let's talk about it. Let's call me. Or email me. Let's talk about the specific situations. Each of these people may have their own entitlements, and they should not walk away from them no matter what.
Again, terminationquestions.com, the place to go to answer your questions anytime or ask your questions and look at answered by Lior or a member of his team. Second one for the day as follows. Joanne writes in, says, I was placed on a temporary layoff 2 months ago. Before being laid off, I was just a month shy of hitting 5 years of service with the company. Can I get any severance pay, or have I not worked there long enough?
Well, let's start with the idea, of course, that a temporary layoff is a termination. A temporary layoff does trigger the right to get severance in most cases, or at least it gives you that option to get severance. Right. If you've been laid off temporarily, you have that choice. The choice, of course, is to continue working, accept that layoff, come back to work if the company calls you back to work. And by doing that, by the way, you give the company the right to do it again. Yep. So that's option one. Option two is you can say, no, I'm not accepting this. I am treating this as a termination. Even though company, you may not have intended to terminate me, I am treating this as a termination, and I'm going to pursue my full severance. So right off the bat, this person is owed severance. So she's asking about 5 years of service. Yeah. One of the misconceptions out there, one of the biggest misconceptions, is that severance is only paid for people that have reached 5 years or more. Nonsense. No. Your minimum entitlements may have something to do with whether you've been there for 5 years or not. Forget about that. Irrelevant. Your full entitlements, what really matters, has nothing to do with that. You get severance even if you work there for a month, for 5 months, for 6 months, whatever it is. So yes, after 4 years or 5 years, she could be owed 6 months severance, 8 months severance, even 10 months, depending on the factors. So misconception is wrong. Yes, you're owed severance. You're going to reach out to me and I'll help you.
Your rights when your LTD claim is denied, that in the severance pay calculator, all coming up. But we'll take a short break and get right back at it. 1-855-821-5900 to reach out anytime. Employment Hour in 30 continues. Hang on.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to inyourcorner.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back to Employment Hour in 30. John Scholes, Lior Samfiru, severancepaycalculator.com. That is what it's all about. Tell me about that tool.
Severancepaycalculator.com, the name says it all.
I got it.
Calculates how much you're owed if you lost your job, your severance. You can call it whatever you want. Termination pay, pay in lieu of notice, severance. All is the same thing. What we're talking about the compensation that you're owed if you lost your job. So severancepaycalculator.com, once you go there, you're going to be asked 3 simple questions. Try it right now. Your age, your position, the length of your employment. That's it. You're going to pick from these drop-down menus, and then it's going to tell you how many months' pay you are owed. It's anonymous. It's free. It's easy to use. It takes seconds, literally seconds. And by doing that, by spending those 10 seconds, you're going to find out your actual entitlements. And if you are staring at a severance letter, the delta, the difference could be massive.
Yeah.
You could be looking at a difference of, difference between 2 months' pay and 18 months' pay. I've seen it happen all the time. You don't believe me? Try it out for yourself right now. It's going to take you a few seconds, even if you're not losing your job, even if you don't have that letter. You just want to know how much, or maybe you want to see what, when you let go 2 years ago, if that was right. It's kind of a dangerous thing to do because you may find out you were owed much more. But check it out, severancepaycalculator.com. You can't put in a credit card. Don't even try. And, of course, you have an option right from the Severance Pay Calculator. There's a green button there. If you want to press it to contact me directly so that I can help you get what you're owed, you have that option as well.
Always give an example. We'll do that right now. 49-year-old Chris was promoted to team manager after 7 years on the job. 1 year later, he was let go and offered 16 weeks of severance pay. Chris's boss said that because he worked in a non-managerial role for 7 years before being promoted, his severance amount is based on that lesser salary, not his $82,000 manager salary. Is that even fair?
It's not fair, and it's wrong.
Yeah.
So when it comes to severance, the salary that's used to calculate your severance is the salary you're making at the time of termination.
Makes sense.
At the time of termination. So if you were promoted to $82,000 and the next day you were let go for whatever silly reason, then your severance is based on your $82,000. The fact that you were making less money before doesn't change that. But by the way, it also works in reverse. So if you were making a lot of money and then your position changed and you're making less money, maybe you went down to part-time and then you're let go, then your salary or your severance is calculated based on, again, what you were making at the time of termination. But it's not just about how many, or what kind of salary is going to be used. It's also about how many months' pay you're getting. So we talked about the severancepaycalculator.com. You read a scenario. Let's plug that information into severancepaycalculator.com to see what this person is actually owed. So middle manager position, you see that on the screen right now, 8 years of service, 49 years old, making $82,000. He was offered 16 weeks, by the way, calculated improperly. Well, Severance Calculator correctly assesses him as being owed 12 to 14 months' pay. That's a delta of over $60,000. Real scenario, you didn't make those facts up. We got that from the website, terminationquestions.com. So because of that, I want you to do the same thing for yourself. Just like this person, an extra $60,000. Huge amount. Don't believe me? Try it out for yourself. I promise you it's a lot more than you realize. Terminationquestions.com.
EmploymentHourTV.ca, once again, the place to find a radio show. From it, we pull our third phone call of the day.
I'm a construction manager and another associate mine. We both used to cover a geographical area. They recently let the one person go, so now they're expecting one person to do the workload of two used to do before. It's more work on me, more windshield time on me. I'm sort of a month or so into the process.
Yeah. So this is not a direct change in terms of his employment. Oftentimes, the change is very obvious. You were in position A employee, now we're putting you in position B.
Right.
Remember, that's something an employer generally does not have a right to do. Your employer cannot change the terms of your employment in a significant way. Well, this is kind of like doing that. You used to do a particular job, now you're essentially doing double the work. So if you can establish that you're doing double the work, that your job as you had it before is now very different now, you have the right potentially to treat that as a constructive dismissal and leave with your severance. So doubling your workload, giving you someone else's job in addition to your own, making your job different from what it was before in any real significant way is something company cannot do and often does lead to a constructive dismissal. So if you're in a constructive dismissal situation, you have an option and you have only a short window to exercise that option. The option is you can accept the changes, accept that new job, or say, no, I'm not accepting it, And if the company still implements it, you can treat that as a constructive dismissal. But if you wait too long, if you take your time taking this job, working in this new job, you will be considered to have accepted it. And then you're stuck, then you cannot get out of it. Not a good place to be in. So in this situation, doubling the workload, constructive dismissal, you may find yourself in the same situation.
Can you still do that even if they give you a little more money?
Yeah, he can.
Wow,
He absolutely can. So they may say, yeah, we doubled your workload. We're going to give you some extra money. You do not have to accept that. You can say, thanks, I appreciate the money, but I want to have my old job. And if they still change it, you may be able to do constructive dismissal. One last piece of advice when it comes to constructive dismissal is if you're going to go that route, don't quit before you talk to me. Okay, we have to do this right. We have to paper it properly. So let's talk first before you walk out of there in a big huff. And then once we talk, we can get you out of there, get you your severance package as well.
Coming up, your rights when your LTD, your long-term disability claim is denied. That is on the way. We'll get your partner, Sivan, on the show after a short break. More Employment Hour in 30 is on the way. Stick around.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to inyourcorner.ca. You thought you had a secure job. You didn't see it coming. Now what do you do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Hey, welcome back to Employment Hour in 30. And all of a sudden, there were three guys on here. We got Sivan Tumarkin, the host of In Your Corner, the first and only show about disability law. If you haven't caught it, I'm sure you will sometime. You can reach out and to find out where you can see the show. You can call Lior, as a matter of fact, 1-855-821-5900 in that regard. So, pal, welcome back. What you got going on today? How are you?
I'm very good, John. How are you?
Yeah. Beautiful. So a little brief synopsis of what you do, what we do, actually.
So my team at the firm, and we work hand in hand with the team that Lior manages, is we handle long-term disability claims. People who have been cut off or denied unjustly by insurance companies their disability claims. And there are a ton of those people. Yeah. They get cut off or denied by the disability insurer, and then they get pressure from their employers. And that's what's so special about our firm, is that we can help them on both sides. With the insurance companies, fighting back against the insurance companies, forcing them to pay what they owe, as well as with the employers.
You know, there's a lot of crossover between what you two guys do in the firm. There's also crossover on the radio show, Employment Hour in 30, and the Employment Hour, that we get phone calls about LTD. So we pass them off to you, and we've captured one, and we're going to play it back here on this show, and I know you want to comment on it.
3 years ago, I had some procedures on my back. During that time that I was off for my back, I was told that I didn't meet the requirements for permanent disability or disability benefits anymore. And so they cut my benefits off and told me I had to show up for work or I would be terminated from employment.
It drives us nuts. Even on your show, we talk about this all the time.
It drives me crazy.
Didn't meet the criteria.
And the thing is this, it's so common, right? And people think that if the insurance company said so, then it's gospel. Nothing can be further than the truth. Yeah. They're trying to make you think that you have no power. They're trying to make you think that you have no options, and they'll invite you to appeal that decision. And you know, the reality is that it's a lot easier to fight insurance companies than you think. And I can tell you that as somebody who used to work for insurance companies. So that gentleman who's calling right now, here's the truth of the matter. As long as his doctors are telling him and the insurance company that he's disabled from working, he should qualify. That's it, period. And you know, if we get involved, when we get involved, what we do is we start a legal claim. That forces the insurance company's hand, that forces them to the table, and that's how we get them to resolve the claims justly, to put the money on the table that they should have put on the table from the beginning. But again, they're counting on people walking away. They're counting on people backing off, being afraid. you should not be afraid to fight an insurance company. That's what we do each and every day.
Again, In Your Corner is the show that Sivan and I host, as well as Lior. We do your show as well. And from it, another good website is mydisabilityquestions.com. You can go there and ask your questions. Sivan answers them himself or a member of his team. I got one here, Sivan. I'm going to throw it at you from Sarah. She says, my long-term disability claim was denied almost 2 years ago. I appealed the insurance company's decision. We love that, but was unsuccessful. That's a shock. Can you help me with my third appeal to improve my chances of success?
So listen, we can help, but here's something you have to keep in mind. First of all, these appeals are internal processes within the insurance company. They are useless. Insurance companies want you to appeal. Now, this person who's writing us, Sarah, she's saying that she's almost 2 years out from when she was denied. Here's something that many people don't know. If you cross that 2-year mark from the time you were first denied, your legal claim may be extinguished. That is what the insurance company actually wants to do. So you don't spend time, you don't waste time on these appeals. These are detours. They're never going to get you anywhere. This is where we apply pressure. We start a legal claim. We go outside of that appeals process, and we force the insurance companies to come to the table. Yeah. But if Sarah misses that 2-year mark, all that money that's owed to her, and we're talking about tens, if not hundreds of thousands of dollars, that stays in the insurance company's pocket, not hers.
Want to get to an email for you, Sivan, help@inyourcorner.ca, by the way, is the email address to reach out anytime. Cole writes in, says, I was just let go from my job after 10 years. I still haven't signed the severance offer, good for him, which was for 10 weeks pay. I'm currently on long-term disability, but that is coming to an end soon because my insurer says I've reached the 2-year mark. I'm confused about what I do now.
Well, so obviously there is an employment component here that Lior can talk to, but I can tell you, many people contact us telling us the insurance company told them they're reaching that 2-year mark, that magical number. All that happens during that time, that when you reach that mark, is the test for disability changes from can you do your own job to can you do any job for which you're suited for by training, education, and experience. Again, it's very simple. If your doctors are saying, and you know, that you can't return to any type of work because of your disability, you should continue getting LTD beyond that 2-year mark. They want you to think that your rights expire at the 2-year mark. That is wrong. It's wrong if you are disabled from doing any job. And again, that's where we step in and force the insurance companies to the table. But again, many people actually don't take advantage of that. They simply take what the insurance company says as gospel. And, they leave money on the table, money that's owed to them and their families.
And 10 weeks pay.
Well, yeah. I mean, can you imagine after 10 years, 10 weeks? But by the way, we here, the three of us, know that that's bad. But if you ask some people on the street, they would have said, yeah, that sounds right.
Yeah, it's a week per year. We're good to go.
A week per year, that's not bad. That's normal. It's not even close to being normal. Remember, the factors are your age, your position, and the length of your employment. So after 10 years, this person could be owed 12 months pay. Forget about 10 weeks pay. So not only is she potentially getting cut off the insurance policy wrongly, when she should be on, she could be owed another year's pay here just on severance. That's why we're able to work together and to help these individuals. And she could go to severancepaycalculator.com, just as easy to find out how much she's owed. And Sivan was talking about insurance companies leaving the money in the insurance companies' pockets. Insurance companies have what we call reserves. Right. They're putting money aside to pay your claim. But you can't get that money unless you start a legal process. So very important to do that so that you can get what you're owed.
Again, that's a huge statement. We've talked about that on In Your Corner on your show. People don't realize that, there's a claim. Okay, guys, we'll keep this stack of dough over here just in case. People don't think they do that. They just say, okay, we got to find money somehow to pay this guy. That's not the case. They have it.
They have that
money there.
They know exactly how much your claim is worth. Their goal, the goal of the adjuster, is to pay you as little as possible, if anything. And if they can make you think that you have no rights, if they can make you think that you're not owed anything, all that money, all that, and I'm talking about tens, hundreds of thousands of dollars, that is kept with the insurance company. It doesn't go to your family. And here's the other thing. When we resolve these claims for you, especially for future benefits, that money is tax-free.
Right.
Again, you may not know that because the insurance company may not tell you that. Don't take what they say at face value.
And by the way, it does make a difference. We've talked about this on your show, that the reserve goes up when you get a good law firm. They see who's handling the case. We need more.
That is a huge, huge factor for insurance companies. And again, I can tell you as somebody who worked for insurance companies, we would always look to see who is the lawyer or the law firm on the other side, and that would affect how much money we would pay out.
Again, inyourcorner.ca to catch Sivan and myself doing that show. And you want to reach out to both these guys, 1-855-821-5900. Never, ever, ever forget severancepaycalculator.com. That is a key place to go. You want to find out what you're owed, what you're properly owed. That is a 30-second test on that website. You can reach out to Lior at that time as well. Help@inyourcorner.ca. inyourcorner.ca is the email address. And there's also help@employmentlawyer.ca as well. You guys are all over the internet as well.
Easy to contact us. We're easy to find. No reason not to reach out.
Appreciate you joining for this show. We'll catch you again on In Your Corner and Employment Hour in 30.